Hello, everyone. Good afternoon, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy, and I am the Marketing Manager at Schoeneck King. I'd just like to go over two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows throughout today's program. Once the webinar has ended, we would appreciate you taking a moment to complete the survey. Your questions and your comments and suggestions are important to our panelists and provide us with topics for future presentations. So it is now my pleasure to introduce today's moderator, Andy Bobrock.
Kathy, thank you. Great to be with you. Great to be with everyone today. Hope you all had a relaxing and enjoyable Labor Day weekend. I know I did. It was a good one, for the most part, weather-wise here in Central New York. We've got a great panel again here today. In just a week's time since our last webinar, there's been many significant developments that will impact New York employers in various ways. We're going to try to cover some of those and address some other emerging topics of interest. To start, I just wanted to briefly mention over the weekend, many of those who are attending the webinar today may have noticed our governor announcing and directing the Department of Health to issue the designation of the sufficient conditions that will then activate your HERO Act plans. That took place yesterday, and commensurate with that directive, the State Department of Health also issued the order. So in that order was indicated to continue until later this year. And I expect we'll see more and hear more about that. So again, what that's going to do in a nutshell is to require you to activate your HERO Act plan that's been on the shelf since you had it crafted. There's other steps and information that'll need to be taken and distributed. We are planning right now a pop-up webinar that will go into more detail about what exactly employers are going to do in terms of next steps. I anticipate we'll have many questions today about that. We'll certainly look at those questions and take them into consideration. But since we're going to be covering this on a separate breakout webinar, it's really appropriate for a more lengthy presentation. We're not going to go into extensive detail today. Again, I expect that webinar is going to be at 3 p.m. tomorrow, Wednesday afternoon. For those who receive our notices of this weekly webinar, we're going to include you and make sure that you, as well as our clients, receive an invitation to that webinar. So details to follow there, but certainly a significant development for New York employers. Speaking of significant developments for New York employers, I'd like to welcome Katie Anderson. Katie, as always, has been keeping her ear to the rail on all things Albany related. And once again, we saw a number of very significant developments that we wanted to give you an overview and briefing of. So Katie, great to have you with us again today.
As always, it is fun to be here, and we have a significant amount to talk about today, more than usual. So let's get to it. First, I'd like to start it off with a bit of culture. This is one of my favorite lines from the show 30 Rock. It's "What a week, huh?" And he goes, "Lemon, it's Wednesday, but you know, today it's Tuesday. It already feels like we've had an entire week that has gone by, and it's only Tuesday, and yesterday was a holiday." So here we go. Looking at our new reported cases, again, we are seeing a plateau, but some of these numbers are a little I'm very concerned. Let's just put it that way. Labor Day numbers obviously are skewed. There was not as much testing occurring at all. So it does show that there was a dip because of Labor Day. However, based on what we're seeing, things aren't necessarily going the way that we want them to go. So let's take a look at what's happening with these numbers, right? So the percent change is technically a 14-day, over the 14-day period, it's been a 4% increase in COVID in New York. But really, excluding the Labor Day numbers, it's closer to a 10% increase. which is not where we want to, the direction that we want to be heading. And there are lots of, that it goes with colleges beginning, that goes with schools resuming, sports resuming for schools. And this week is the beginning of school for most New Yorkers. So we will really be watching these numbers closely. Again, you're seeing hospitalizations continue to tick up, death rates continuing to tick up. So that is very concerning to me. And we're going to have to really watch closely over the next few weeks, especially with schools beginning, what's happening with the numbers in New York. Just one thing to mention as well, there have been a lot of discussions about this new variant, the mu variant that was discovered in Colombia earlier this year, very early in this year. This variant has been reported in every single state except for Nebraska. It constitutes a very low amount of the cases in every state. Ultimately, Delta continues to be 99% of the cases that we're seeing in this country. This new variant, while they have concerns that it may be more vaccine resistant than the Delta variant, it is not transmitting at anywhere close to the same rate that the Delta variant is transmitting. So keep your eyes posted, keep them out, look out for this new development. But really just, I think it's more worthwhile to be focused on the variant that's raging like a wildfire across the country. Our vaccination progress, every number has begun to tick up. And as you can see, I decided to start looking at the 12 and older in terms of who is considered fully vaccinated and who has one dose, because those who are 12 and older may now receive the vaccine. So 12 and older, we are at 70% fully vaccinated and 79% have received one dose. So that is good news, especially when we're looking at the fact that schools will be beginning this week. Speaking of schools beginning this week, let's dive into what happened last week. Last week, the Department of Health put out this guidance on September 2nd about how classroom instruction will occur. If you can remember earlier, a lot of this guidance got caught up in the transition to a new governor. Governor Cuomo basically directed the Department of Health to not issue this guidance. And one of the first things that our new governor, Kathy Hochul, did was direct the Department of Health to prepare this guidance to be issued pretty much immediately. So this was as fast as they could put it together. So let's look at this really quickly. Schools. So the main thing here is that a lot of the strategies and mitigation measures in this guidance documents are up to the local school district. It's up to the Board of Education. Unless it says, must do this or must do that. A lot of this is up to the local health department and the local school district. So there is an amount of local control over this guidance. Turning to, what's required under this guidance. The first thing is under the regulation, and as we discussed last week, masks are required for all indoor activities, unless you are eating, drinking, singing, or playing a wind instrument. Also, there is a physical distancing, I want to call it a requirement, but, pretty close to a requirement, one step down. It's strongly recommended that there will be at least 3 feet of distance between students indoors, and 6 feet is really optimal. You'll see why this is important in a second. I promise that 3 feet will come back. It's when you look at the quarantine and close contact requirements that are for schools. So in the school, generally speaking, and this is just generally speaking, period, a close contact is considered when you are within 6 feet of an infected person for a cumulative total of 15 minutes or more over a 24-hour period. What does that mean? That means you could be next to somebody for 5 3-minute intervals over a 24-hour period and within 6 feet of them, and that would be considered a cumulative total of 15 minutes. But a big but here. students that are fully masked who were within 3 to 6 feet of an infected student is not considered a close contact. That does not apply to teachers. It does not apply to staff. It applies to students. And that's a really important distinction. And that's why that 3 to 6 feet thing really matters here. Because if your students are at least 3 feet apart and you have one infected student in that classroom, the rest of the students will not be considered a close contact so long as everybody was masked appropriately. So that is really something to pay attention to in your school district. Finally, fully vaccinated people don't have to quarantine, but they should be tested 3 to 5 days after they are exposed to COVID. But they do need to quarantine if they develop symptoms. That is consistent with the rest of the quarantine guidance that we've been looking at for private businesses and elsewhere. So an important aspect of the schools is that anybody with new or worsening symptoms of COVID-19, they need to be excluded from school regardless of their vaccination status. So if you start developing symptoms of COVID that are not your typical fall allergy, I'm very allergic to ragweed symptoms, then you need to be quarantined. You can return either 10 days after your symptom onset, and you have to remain fever-free for 24 hours, or you have to provide proof of a negative COVID-19 test. And those negative COVID-19 tests need to be specific tests. It should not be a rapid test. Further, looking at what the testing requirement is in schools. So screening, if you have, and we went over this last week, staff and teachers who are unvaccinated need to be tested weekly. Schools have to offer weekly testing to unvaccinated students in areas that the CDC has designated as having a moderate, substantial, or high transmission rate of COVID-19. So until you get into an area where you are in a low transmission rate as designated by the CDC, you have to be offering screening, weekly testing screening to students. Also, after an exposure, diagnostic testing has to be provided to everyone exposed. For schools on the line that have questions about this, please contact our school law group. Contact me, I will put you in touch with them, or I will answer your question. But there are lots of issues here about, can pool testing occur? So make sure that you are really reading this guidance document that came out. It's very important. And that is the end of the school part, but don't worry, we still have a lot to talk about. First, last week we had an extraordinary legislative session, and I'm not just calling it that because it was extraordinary. I'm calling it that because that's its legal term. When the governor calls the legislature back for a special session, it's called an extraordinary legislative session. So what happened? First, we had an extension of the commercial and residential eviction moratorium. That is in place until January 15th, 2022. There are new measures in there that the landlords can take to contest the tenants saying that they are, have financial hardship. That was put in there so that it would be constitutional based on the Supreme Court's recent ruling against New York State's eviction moratorium. Also, we finally have nominations and finalized appointments now for the Cannabis Control Board and the Office of Cannabis Management. Totally different vibe than the eviction moratorium. But why this is important is now they can finally begin to put forward the regulations or put together the regulations that will be required in order for the legal sale of marijuana to occur in New York State. So that is big news and welcome for those who are trying to get in the business of legal cannabis sales. Also, and very importantly for public employers on the line, the open meeting law, there is a temporary extension of virtual public meetings. So effective immediately, effective as of last week, virtual public meetings are allowed again. This is in effect until January 15th, 2022. There are many good government groups that are criticizing this. So if this is of interest to you, then this will be something that you will really need to be looking to advocate for in the future, because this will be an uphill battle to get this in place permanently. But the good news is we have it in effect until January 15th. Turning to another breaking news development, last week we saw record flooding in New York City. There was a declared state of emergency. So that means, and also there is coordination to receive federal funds in the impacted areas, especially in the New York City area. Why does this matter? If you are trying to receive those federal funds, if you're trying to receive state help, you need that state of emergency in place. Turning to the vaccine mandate for healthcare providers. Andy, when he asked me to do this, he didn't know I could give the whole webinar, but I told him I could talk for a while on things. All right, so turning to the healthcare providers vaccine mandate. There is still guidance that we are awaiting about who needs to comply, what entities are considered to be Article 28 entities under the public health law. That is still a question that has been floating around. But there is a very important aspect of this mandate is that there's no religious exemption. There is precedent for that in New York State. The public health law does require vaccination for measles, and there is no vaccination exception under that section of the law. That has held up in court. And that came about in 2018 when there was a severe measles outbreak that was occurring, and it was centered in New York State. So we do have precedent here for no religious exemption. It will remain to be seen how this morphs into other places. Just theoretically speaking, if this holds up in healthcare, once there's full approval for the vaccine for children, I would not be surprised if we are starting to see the legislature have the appetite to pass the law that would require the mandate. However, the legislature would have to pass a law to do so. This would really likely be outside of the Department of Health's purview. However, the Department of Health absolutely has the authority to pass this regulation to require vaccines for certain healthcare providers. Again, if you have questions about that, please come talk to us about it. We have a very dedicated team of healthcare lawyers who are, really looking into this. Andy, I see you unmuted yourself.
I did. I'm sorry. I don't mean to intercede here, Katie. Just a couple thoughts came to mind on this issue. First, on hey, is my office deemed a healthcare provider area that needs to adhere to the vaccine mandate? And as you correctly know, we look to Article 28 of the Public Health Law, and this is an issue that we have worked with a number of our clients on already. There is a process where we can work through that issue and provide guidance on that. There's not necessarily going to be a one-size-fits-all answer, but to echo what Katie said, contact us. We can work through that issue and get you guidance on that. With respect to the religious exemption, again, I agree wholeheartedly. There is none in that mandate. It is notable. And one of the issues that comes up in the course of my practice as a labor and employment attorney is this tension that exists between the mandate and the lack of a religious exemption. The tension with that between federal law, for example, which requires employers to accommodate an employee's sincerely held religious belief. And how do we work through those issues? This is something that perhaps you're wrestling with. I know that and my partners and our associates here have worked with a number of clients on these issues. And again, it's something you're going to have to work through with legal counsel and assess, but there is pathways to address those issues. And certainly there are things that we've looked at to this point. So just wanted to offer those two tidbits, Katie, thank you.
Perfect. It gave me the opportunity to drink some water because talking for 10 to 15 minutes straight does require hydration. So I appreciate that on the personal level. So looking at the next area to discuss, I figured, I know Andy talked about it up front, but I knew we were going to have some people joining late. So the HERO Act, there has been that the official designation has gone into place now that does activate the HERO Act. 4 questions on the HERO Act. Again, we are doing a webinar tomorrow. It will likely be at 3 o'clock in the afternoon. You will likely receive an email about that soon. But one thing to really note here is that if you look at this is the website page to go to for the HERO Act, but in the meantime, something that you can do is go ahead and go to that page, pull up the standard on that page, and go to section B-8. Section 8 goes through what you have to do as an employer when the plan needs to be implemented. Ultimately, you know, it doesn't have any specific answers to a lot of your questions that I'm sure that you have, but it does go through, you know, what are the first and immediate steps that need to be taken. That includes a verbal review, which I'm sure will be discussed tomorrow at length. And I'm sure a lot of other questions about, you know, what do we do with customers, all those things, those will be discussed tomorrow. And you can feel free to come to us with those questions because this is so quickly developing. It is important to give us a call about this. We haven't really been able to discuss this. You know, it's very breaking news, so we can't really give you too much right now without it being considered legal advice.
Oh, thanks. Yeah, Katie, that's helpful. We're getting, as you expect, a lot of questions on the HERO Act. And again, we're going to cover it in depth tomorrow. One of the questions we're getting over and over again is, hey, you know, what does this mean, this DOH designation? Is there some grace period? Is there some waiting period? As we were sitting here, I didn't recall one. I went back and looked at the guidance and looked at the statute. I didn't see any really in there. It was more so, if that designation is made, then thou must put the plan into effect. So again, think of it as taking it off the shelf and now putting it into effect and reviewing that plan to determine if and what steps we need to take in the short term. And so I think that's where I would start. We're going to drill down tomorrow, but if you're looking to get ahead of the curve right now, take a look at your plan, understand what it contains. Chances are many of you simply adopted a model plan that the state put out. And inevitably, there are going to be some gaps in terms of how should we handle situation X, Y, and Z. And we're not necessarily going to have clear guidance on all those issues, but you know, we're really defaulting back to that period of time where we had to make decisions based on the information that we had, exercising caution and care. And I appreciate and understand there was a measure of comfort in having clear directives on any number of issues, but we've never had anything completely comprehensive. So we're going to have to make some decisions. But the good news is there's a lot of information out there. We have a track record of what we've learned over the past over a year and a half, and we can use those lessons and make good decisions moving forward today. But again, yes, I think the short answer is those plans, we're taking them off the shelf and they need to go into effect now. And I'm suspecting too, there may be 1 or 2 of you on this call who don't have their plan, right? And that's okay. But let's get that plan together and be ready to implement that ASAP. All right, so that's my advisement there. Katie, did you have anything else?
Nope. Let's just, hope next week, if it's this long again that I have to present, I'm going to need an IV for water.
We'll make sure, yeah. Nourishment and hydration. We'll take care of our presenters always. And speaking of which, glad to welcome DJ Nugent here. DJ, you've been hydrating during the course of Katie's presentation, which is good to see too. Want to make sure everybody's healthy. DJ, one issue that we've gotten a lot of questions on, and I think it was the Delta Airlines that came out with, was it Delta or United? I forget.
It was Delta.
Delta, okay, yeah. Delta came out and they were charging their non-vaccinated employees a surcharge essentially associated with their health insurance. And we got a lot of questions and interest from clients and others about, is this possible? How can this happen? What other, incentives are out there that maybe could work to try to encourage people to become vaccinated? So DJ works in our employee benefits group. This is an issue that he's been tracking, and wanted to invite DJ just to speak briefly about this issue. Thanks, DJ.
Thanks, Andy. So like Andy said, the focus of this is going to be COVID vaccine incentives, in contrast to what Katie and Andy spoke about previously with kind of vaccine mandates. Instead of requiring your employees to get the vaccine, trying to incentivize them to do so. I spoke on this topic in May of this year, kind of in a different light. A lot of our clients were talking about maybe giving cash payments or gift cards or other things, maybe laptops, something like that, to incentivize employees to get the COVID vaccine. The framework is similar, but there's some additional considerations if employers want to go the route that Delta Airlines went. So like Andy said, Delta Airlines announced that their unvaccinated employees are going to have to pay more for health insurance than their vaccinated employees do. A lot of people are saying, is that possible? The general answer to that question is no. Group health plans and insurers are prohibited from using health factors to discriminate against similarly situated individuals. In this instance, vaccination status is the health factor. The exception to that rule is for wellness programs. A lot of employers already have these in place. They can be smoking cessation programs. They can be just kind of general wellness, maybe walking, health screening, BMI reduction, all those types of programs that employers may already have in place, where they charge employees a lesser premium if they meet those requirements or participate in those programs than employees who do not participate in those programs. So the COVID vaccine incentive charging different premiums for vaccinated versus unvaccinated employees would fall into those same wellness programs and can be an exception to the discrimination rules. Wellness programs that provide for premium differentials implicate a myriad of legal issues. This list is not exhaustive, but these are the four I'm going to talk about today. So there are issues that come up under the Health Insurance Portability and Accountability Act, HIPAA, the Americans with Disabilities Act, the ADA, the Genetic Information Non-Discrimination Act, which is GINA, and the Patient Protection and Affordable Care Act, which I'm going to refer to as the ACA. Next slide, please, Kathy. So when we're talking about COVID vaccine incentive programs that are structured to provide premium differentials, the analysis really starts with HIPAA. Wellness programs can fall into several different buckets under the HIPAA rules. Our best read is that COVID-19 vaccination incentive programs are likely going to be classified as what's called an activity-only health contingent wellness program. And unfortunately, these programs are subject to the most stringent requirements under HIPAA. I'll go through some of the requirements that apply to these types of programs. I think the most notable is the limitation that is applicable to these incentive programs. So under HIPAA, incentives generally cannot exceed 30% of the total cost of coverage under the employer's health insurance plan. That's both employer and employee contributions. Just as a brief hypothetical, if on an annual basis, health insurance coverage is $10,000 and an employer wants to institute one of these programs, they could charge vaccinated employees the $10,000 for the year and unvaccinated employees up to $13,000. Or conversely, they could charge unvaccinated employees 10 and vaccinated employees 7. That's using that 30% number based on the 10. And that is the limit. You can, of course, do less if you want to do less. So that's the first requirement you really need to be aware of, is how much that these premium differentials can be. The second requirement that I'd like to highlight under HIPAA is that there's a reasonable alternative standard requirement. This is very similar to the ADA's reasonable accommodation requirement, and it requires a reasonable alternative standard or waiver of the standard be provided to employees for whom it's either unreasonably difficult due to a medical condition to satisfy the standard, or for whom it's medically inadvisable to satisfy the standard. So in the COVID vaccine incentive program, the standard is getting the vaccine. So the HIPAA reasonable alternative standard requirement would say if for one of these reasons an employee cannot get the vaccine, the employer either needs to provide an alternative standard for them to meet or just waive that standard. You don't have to get vaccinated and you don't have to do anything else if you come forward with one of these reasons. So again, very similar to the ADA's reasonable accommodation requirement, but HIPAA has its own set of rules on how that is implemented and how different terms are defined, things like that. Next slide, please, Kathy. So other things to consider under the HIPAA non-discrimination rules, in addition to the incentive limit and the reasonable alternative standard, HIPAA also requires that your wellness program meet various other requirements. Some of these requirements are the frequency of reward, that the program be reasonably designed, that there be uniform availability of the program, and also notice of availability of the program. Again, a lot of employers are going to be able to meet these requirements under HIPAA, but it's just important that if you do want to go down this path and implement a COVID vaccine incentive program that is using premium differentials as the incentive, that you're just aware that you have to check all these boxes under HIPAA. Next slide, please, Kevin. In addition to HIPAA, some of the other laws that apply are the ADA, GINA, and the ACA. So importantly, the ADA and GINA also impose incentive limits on COVID-19 vaccine incentive plans. Based on some EEOC guidance, what that incentive limit is under the ADA is vaccine incentives are permissible so long as the incentive is not, quote, not so substantial as to be coercive. The EEOC has not really provided any guidance on what that means. Our best read is that that number is someplace less than 30% of the health insurance cost for the year and someplace more than maybe a gift card or a water bottle. But in any event, we're pretty confident in saying that it's a more restrictive limit than what HIPAA imposes. The good news is that same EEOC question and answer guidance says if an employer merely requires proof of vaccination from their employees, so their employees get the vaccine in the community or at their own doctor, they just come and they show their vaccine card to their employer, or maybe the employer just takes their word for it without any proof, the ADA and GINA incentive limitations won't apply. If the employer provides the vaccine to their employees on their workplace facilities, the employer does it themselves, or if they contract with a third party, you have CVS or some other group come in and provide the COVID vaccines to your employees, these ADA and GINA incentive limits will apply. So if you're in that group of employers, the limit that you can provide to your employees is pretty restrictive. Some other ADA considerations other than the ADA and GINA incentive limits is we recommend, and I think it's probably required even in addition to HIPAA, is to conduct a reasonable accommodation analysis that's both medical and religious objections to getting the vaccine. Don't discriminate in how this program is rolled out, and also keep any medical information that you may obtain as part of this program confidential. So those are the ADA and GINA requirements. I just want to briefly mention an ACA consideration. When you structure a wellness program to use a premium differential, that creates an issue under the ACA's affordability requirement. So very briefly, what's referred to commonly as the employer mandate has two prongs. One, that you offer minimum essential coverage, and two, that coverage is affordable. If a wellness program provides for premium differentials as the incentive, that second prong, the affordability prong, is implicated, and you just need to make sure that you're not creating any issues under the ACA under that rule. Next slide, please, Kathy. So Andy, that's all I have on this. I think the takeaway is yes, like Delta Airlines, employers can charge different premiums for vaccinated versus unvaccinated employees so long as these various requirements are met. And what the incentive is going to depend on whether the employer has provided the vaccine at their place of employment or if they're just requiring proof.
DJ, thanks a lot. I think it's helpful for our clients and friends of the firm to understand, if they're considering this, that there are several needles that need to be threaded along the way. And I know for me, DJ, you'd be the first person I call on this. So thanks for all the background and information, and really for taking a deep dive on this. It's a great resource and asset for the firm, and I know our attendees appreciate it. So thanks again. Thanks. All right, next up, we just wanted to give a very quick update from Paul Bueller. Paul is an associate who works in our Albany office on a wide variety of labor and employment matters. One of the issues that Paul's done a great job of keeping track on is all things unemployment insurance. As I suspect many of you are aware, we had a significant development in that the additional pandemic assistance that was provided through the UI programs has been completed and ended. And we just wanted to give Paul a couple minutes to come on and just talk about that briefly. Paul, thanks.
Thanks, Andy. And, I know that Katie and DJ gave you guys a lot of information to digest, so we're going to keep this pretty high level, pretty quick. Basically, I've got some good news for everyone and a little bit of bad news for a handful of you guys out there. So good news, we've all been tracking, I'm sure, the CARES Act and the American Rescue Plan expansion of the unemployment system. It basically allowed people to receive benefits in situations where they otherwise were not eligible. And there were some tack-on dollar amounts, initially $600 per week. It later became $300 per week. All of that expired yesterday. So what that means moving forward is that we're going to return to the normal unemployment eligibility system. So somebody has to lose their job through no fault of their own and be ready, willing, and able and actively seeking employment, again, under that normal eligibility criteria in order to receive benefits. And the maximum weekly benefit will reduce now to $504 per week here in New York. So that's good news, I think, for everybody. As far as I've seen, there have been no plans or proposals to extend that eligibility or renew the expansions under the CARES Act and American Rescue Plan. I think a big part of that is, first off, states across the nation have paid out over $700 billion in unemployment benefits over the last 18 months or so. And unemployment numbers are actually at their lowest right now that they have been over the course of the pandemic. So bottom line, we're going back to the regular system, and that should make it a lot easier for a lot of you guys to recruit new talent, and it should also make it a little bit easier to contest unemployment benefit claims. So now the bad news for a handful of you guys, and that is you self-insured nonprofits. So those of you who are out there, self-insured nonprofits, were receiving basically relief from your normal unemployment benefit claims. The CARES Act provided a 50% reimbursement, so you would only have to basically pay half of the claims that your former employees were receiving, and then the American Rescue Plan increased that to 75%. With the expiration of the CARES Act and American Rescue Plan UI expansion, with that expiration, that means that 50 or 75% relief is now also gone. So your unemployment insurance bills may return back to that kind of normal level. You're going to be paying dollar for dollar. But again, because unemployment claims are at the lowest they've been in the last 18 months, hopefully that is not a huge burden. So that's what I have, Andy.
Oh, that's great. Thank you. I think just to piggyback on a couple of the issues you touched on there. So again, two big pictures for folks to think about. One, that what became a much longer list of conditions that would render an individual eligible for unemployment benefits is now going to constrict back to what you traditionally are aware of. That's where somebody is terminated without having sufficient grounds constituting misconduct, or where they quit with good cause. They'd be eligible under those situations, but not the myriad of additional kind of COVID-related circumstances. And likewise, the amount would be back and revert back to the standard amount that's out there. I guess a word of caution for our clients and friends of the firm here: take a look at those reports that you get. The ramp up to be able to adjust the state's UI systems was an immense and complicated project that boondoggled in any number of ways. And so now we're taking that system they created and we're going back to the traditional system. And I, for one, I'm not sure how smoothly that's going to work. Hopefully it goes very smooth, but take a look at your claims activity and the circumstances with which claims are being paid. The concern being that perhaps a claim's approved on grounds that are not rendering an individual eligible. So closely scrutinize those and make sure that your accounts are accurate and reflect the current state of the law. All right, with that, Paul, thank you very much. Appreciate you joining us. I know you'll be back if there's any other developments on the UI front. Let me just say thank you again to everybody here in attendance. The contact information for all the people who presented today is here as usual. Do not hesitate to give us a call, email, however you'd like to get a hold of us with any concerns or questions. We're happy to help. And just to reiterate, tomorrow, we expect at 3 p.m., we'll be doing a standalone program on HERO Act compliance based on the DOH's designation and activation of your template forms and other model forms. We'll have more information there. Everyone who receives an invitation to attend this weekly webinar should receive an invitation to attend our HERO Act program tomorrow. I expect that'll be recorded and made available for our clients at the very least, possibly our friends of the firm too. More to follow on that. Thank you very much for attending. Everyone be well and be safe in the meantime.